RBI Chennai to address this gathering of tax professionals and other stakeholders. As we convene here today, our nation is poised at the threshold of a new fiscal year, marked by unprecedented challenges and opportunities. Union Budget 2025, presented by our Honorable FM, has ushered in a slew of reforms aimed at propelling our economy towards sustained growth, development, and inclusivity. As tax professionals, it is our endeavor to meticulously dissect the budget provisions, analyze their implications, and provide insightful commentary to our clients, stakeholders, and wider community. This meeting provides a platform for us to engage in constructive dialogue, share our expertise, deliberate on the finer nuances of the budget. RBA has consistently strived to promote excellence in taxation, foster collaboration among professionals, and contribute to the development of a fair, equitable, and transparent tax regime. Through this meeting, we aim to facilitate a comprehensive understanding of the budget provisions, their impact on various industries, and resulting opportunities. I extend a warm welcome to our esteemed speakers who will share their invaluable insights on various aspects of the budget. There are several initiatives in both the direct and indirect regimes, which will be elaborated upon shortly by the esteemed speakers of the day. The budget presents reforms along six main dimensions to support four main pillars of economic activity in the country, namely agriculture, MSME, investments, and exports. The Honorable FM presented the budget estimates for revenue and expenditure for FY 25-26 yesterday. The total expenditure of 50.65 lakh crore were proposed against an estimated revenue of 34.96 lakh crores, leading to a fiscal deficit of 4.4% of GDP, with 11.4 lakh crore of proposed borrowing from the market through the issuance of dated securities. As we navigate the complexities of the budget, let us remember that our role as tax professionals extends beyond mere compliance. We are custodians of tax regimes, entrusted with the responsibility of promoting transparency, accountability, fairness, and justice. In conclusion, I urge you all to actively participate in the discussion, pose questions, and share your perspectives. Let us work together to unravel the intricacies of the budget and emerge stronger, more informed, and better equipped to duly serve our clients and the nation. Thank you.
Thank you, sir. I now request Mr. Swaminathan, member of the Central Administrative Tribunal, to felicitate Advocate Mr. Lakshmi Kumaran. Mr. Raghavan Ramabhadran will receive it on behalf of Mr. Lakshmi Kumaran. I request Mr. Swaminathan, member of the Central Administrative Tribunal, to felicitate Mr. Raghavan Ramabhadran. Thank you, sir. I now request Mr. K. Ravi, Advocate, to felicitate Senior Advocate Mr. Sujit Ghosh. Thank you, sirs. Mr. Lakshmi Kumaran will now deliver the keynote address.
Thank you. Good morning. Namaskaram. The President has just now mentioned that the budget presented by the Honorable Finance Minister yesterday is an era of ushering India into a different economic path taking into account various types of headwinds India is facing as a development happening in US, Europe, and other countries. I've been asked to talk about the policy angle emerging in the budget and the interaction between the policy and the fiscal policy. Very interesting subject. Thank you, Mr. Sridhar, for giving a different topic for discussion. For a change, I am not going to discuss the provisions changes in the custom duties or custom law or GST. I am not going to discuss about the voluntary disclosure scheme which has been brought under the Customs Act, whether it is a gift or a trap. I think Sujit will handle that very competently. I am also not going to discuss about the tough amendment made in the GST law to take care of this safari retreat matter, which he passionately argued for the Supreme Court. I'm going to leave it to him. Nor am I going to discuss about the rationalization of TDS, abolition of TCS, or the grant of the different types of exemptions to the middle class. I think I leave it to Raghavan. As Ms. Sridhar mentioned, what is the synergy which the Honorable Finance Minister is trying to bring between the various policy initiatives and how the revenues are dovetailing that? He mentioned very clearly that there are four main pillars or the focus areas where the Honorable Finance Minister talked about. One is, of course, agriculture, investments, MSMEs, exports. I will also add one more, though she did not mention very clearly. Heal in India. Till now, I've been talking about only make in India. I think now she also indirectly talked about heal in India, medical tourism, etc. They are talking about. HEAL, heal, sir, heal India. I know many people may get doubts. That is, we welcome the patient from outside, we'll give the treatment here. And that tourism also can develop. And then whatever visa facilities are going to be waived, etc., that's also being discussed. Let us now talk about one by one and see how the policy of the government and the fiscal policy are they going parallelly or contradicting. I am going to give critical analysis of what we did in the last few hours. We must realize, as I am speaking to you, in the last about 3-4 hours or so, the President of the United States has imposed tariffs from Mexico and Canada, about 25% each, and also imposed a tariff of 10% over and above the existing tariff from China. It just happened a few hours before. He has been telling that he's going to do it from 1st of February. He did it. We thought it was merely a threat until it has happened. I'm going to discuss in detail about this particular development there in the United States, far away from here, and how it is going to affect Indian economy and what we should be doing in these extraordinary circumstances. Let us first talk about the agriculture. The agriculture, as far India GDP is concerned, it is almost 50% of the GDP from the agriculture. And when I say agriculture, it also includes fisheries, aquaculture, etc., floriculture, vegetable, fruits, etc. I mean, as a whole. And in order to empower farmers, fishermen, and to make their lives easier, several announcements have been made in the budget. I am not specifically mentioning about those announcements made with regard to the empowerment and enabling the agriculture, including fisheries. Suffice it to say that more than 1 lakh crores of revenue or money is being pumped into this sector. We must all realize that when she mentioned that India will definitely provide incentives for the fishing during the exclusive economic zone and also deep sea fishing, we must also realize what was India's commitment and extraction of the agreement in the WTO ministerial agreements in the year 2022. In compliance with that, we are saying that we are going to provide incentives for our fishermen doing deep sea fishing. We as a country, our fishermen never fish for 2 months in a year so that the fish stock can grow. We have been following centuries and centuries. And take all this into account, this announcement has been made. But where do you get the money from? Certainly. You will find in the budgets, there are several commodities where the custom duties have been reduced, basic custom duty. And simultaneously, you will find the agricultural cess have been increased. So on more or less, the rates have been maintained at the same level cumulatively. But the reduction in the basic custom duty and equivalent or slightly more in the agricultural cess is the way in which money is being mopped up. One can ask a question, why did she have to do that? You can as well keep the custom duty as such. The question will be, the custom duty collection has to be shared with the center and the state based on the recommendation of the Finance Commission, whereas agriculture cess need not. So therefore, the entire money collected as agriculture cess can be pumped into this sector. I am not here to argue or at least comment whether this will result in reduction in the revenue sharing with the states. That's for the state government to take up. As a matter of fact, I'm just making a mention. We also talked about investments. When they talk about investments, it's not merely investment in the case of manufacturing facilities. The government is talking about investment in people, skill development, education institutions, increasing the seats in the IITs, medical institutions. We must also take into account that visa restrictions are coming in a big way in the US. You must also take into account that so-called illegal immigrants into US are going to be sent back. We will have reverse brain drain in the near future. It's good for the country. And that investment on the human resources is also being specifically commented upon in the budget speech. On the investments on the manufacturing side is also mentioned very clearly. And there is also a mention about renegotiating all BITs, bilateral investment treaties. India has burnt their fingers in the past, in the BITs, and now they are talking about renegotiating the BITs. And those BIT renegotiation is necessary. It will give better confidence for the investors to come and invest here. India has to move forward halfway through, if not the full way. And that's what exactly happens in the case of treaties. As far as investments are concerned, there is one more mentioned specifically about the MSMEs. I'm going to deal with separately. MSMEs in India, both goods and services sector, have been dealt with very critically by the Honorable Minister. Increase in the threshold of the investments, increase in the threshold of the turnover, both have simultaneously happened. And that is good. Because once you increase the threshold for the investments as also the turnover, the existing concession available to the MSME sector will get enlarged to the larger number of people. And after all, MSMEs constitute more than 40-50% of the manpower production, employment, and the entrepreneurship, including the startups, have to be encouraged. While we are doing so, simultaneously, we also have to look at the domestic market in India and also the export market. That is where MSMEs and exports, they get interlinked. They are not two different subjects. They are actually two parts of the same subject. As far as the exports are concerned, we need the exports. We need the foreign exchange for importing various critical items in India. For the exports and also for the MSMEs, I'm talking them together. What did India do as far as encouraging investments in India, whether it is a large scale or investment? They have been following a principle of phase manufacturing program. The government picks up certain products, and these products should be encouraged manufactured in India. How do you do that? You can't give a discourse to the manufacturers, hey, do that. You need to create an atmosphere. So what they did, for example, in the case of mobile phones, where India decided that we will start manufacturing in mobile phone in India. We don't have to import from China or Korea or other places. What did they do? They imposed a tariff of 15%, 20% on mobile phones. And therefore, imported mobile phones will be costlier by 15-20% straight away, apart from GST, etc. Simultaneously, reduce the custom duty on the components. Therefore, you import the components at reduced duty or zero duty, manufacture the finished goods, and sell in the market here in India. With the result, you will find that manufacturing in India is much more profitable, affordable, and also meeting competition. And once this happened, then the government says, all right, out of the components that are being imported, I want these 5 components manufactured in India. So what did they do? They increase the custom duty on those components, reduce the custom duty on the components of the components. The same thing what they did in the case of mobile phones, they picked up on mobile phone parts. And gradually, over a period of time, encouragement has been made to manufacture the components also here. Now we are going to the raw material stage. That's where critical minerals will come. We'll come back later. So therefore, the government is following a bit policy of how do you encourage manufacturing in India. And today, India has become one of the biggest manufacturers of mobile phone. We are supplying mobile phone from India abroad. And Apple and Samsung, etc., they have huge manufacturing facilities. And Tamil Nadu is one of the beneficiaries of these investments. Now, the government now, I won't say turning, but broadening the focus. What are the electronic items we can do so? How do we do the same thing with electric vehicles? So therefore, you will find the entire budget proposals where the duties have been increased on certain items and component duties have been reduced, and thereby repeating the success story which happened in the case of mobile phones in other sectors. That is what you will find in the budget document. I am sure Sujit will discuss in greater detail about those changes made, if he wishes. Now, having said this, as per the bettering the climatic conditions for manufacture in India, those critical items which the government wants to manufacture here, whether this India's GDP is governed or driven mainly by the consumption because of the population and the very high number of middle class. Therefore, the power of expenditure is more, and therefore, economy is booming. So therefore, the entire economy is based on the consumption. What is that we have to offer to various countries when we are negotiating free trade agreements? What is that we have to offer? The market. Here is a huge market here. You come and manufacture here, or you trade in goods in here, you will be benefited. In return, what I want. The whole bilateral agreement which we are negotiating with Australia, UAE, Switzerland, Norway, or UK, or European Union, or Canada, is all based on one principle that look, you have your own market, your own manufacturing facilities, and your consumption in that particular country is saturated. If you want to increase your production there, you are not likely to get beyond a particular level. As far as India is concerned, we have certain tariffs. So exporting those goods at that particular tariff rate is not going to be easy for you. Let us now discuss bilaterally. How do we reduce the custom duty on these goods? How will you reduce the custom duties? In return, because I am giving you the market for you to expand, what do I get? Increased visas, service exports, generic drugs exports, audiovisuals, so many items which India can produce and sell from here. We ask for in return, apart from the custom duty reduction there. So that is exactly what's happening as far as the bilateral is concerned. The last 3-4 years have been enriching experience for me in negotiating these agreements. As lawyers, we normally will interpret a provision. This is right, this is wrong, etc. But how do you get the law? How do you negotiate the agreements? How do you ultimately draft it? How do you vet it? How do you remove those inconsistencies? It's a very big task. While I'm talking about these bilaterals, now look at what's that happening elsewhere. If India has to export, and if it has to have the billions of dollars in its kitty, you can't ignore what's happening elsewhere in the world. The 20th January 2025 is an important day for the whole world because President Trump has taken over the president on that day with a massive mandate. Trump administration 1.0 did something. 2.0 is going to do so many things which I don't think I can enumerate now. Probably he cannot also as he progresses. But one thing is clear. The world, all the economies, particularly in United States, in 90s, were very clear that for the world to proceed, and if the trade has to go among the countries, we need to reduce the tariff barriers and non-tariff barriers. There is no other way. The movement of goods and services across the border can take place only when the tariffs and non-tariffs are reduced. US was the main proponent along with the Europe. And GATT agreement were negotiated, Uruguay round, signed, effective from 1st January 1995. And the law of jungle, might is right, was given away. Rule of law, the trade and commerce across the border should follow certain rules, as mentioned in various articles of WTO. Violation of this will be dealt with by the dispute settlement body and the appellate body in Geneva. And the decision of the appellate body is final. It will be adopted by the WTO. Other country which has lost must implement it and fulfill their obligations. That's the law. The first term of Mr. Trump, he felt that the appellate decisions of the WTO statistically more were against US. Therefore, he felt, why should I have this appellate body? He vetoed the appointments, and therefore there is no appellate body now to decide the matters. That has been done in the Trump 1.0. So therefore, there is no question of any dispute being settled at the WTO level today because there is no appellate body. Having done so, now in the 2.0, he first of all comes and says, I am going to impose tariff. Imposition of tariff against one particular country is a serious violation of WTO because WTO talks about MFN treatment, most favored nation treatment. It cannot have selective duties. It is just against the principle enunciated and propagated by United States in the 90s. In 2025 is totally different. He says, I will impose. And the excuses which he gives for the imposition of these duties is flimsy. In any case, if it is matter being appellate tribunal of the appellate body in the WTO, his actions will be set aside probably in a matter of 1 or 2 hours. But the body doesn't exist. He can do what he likes. The law of jungle is now prevalent. Might is right. I am United States. I can do what I like. You better follow. We have now seen Mexico and Canada have been slapped with 25% duties in excess of what has been already been imposed. And so also China, about 10%. Fentanyl imports into US through Canada border and Mexico border are the reasons for imposition of these duties. As of now, there has not been duty been not imposed against India. How long it will continue, we do not know. Now, what is that we can do at this point of time? Pray God, sir, please do something to the President of the United States not to impose duties or something more. Is it not the right time for India to start negotiating in the United States for free trade agreements? If there is any reduction in custom duty necessary, instead of making it for all, will it not be advisable to reduce only for certain goods from United States? And in return, we can ask for so many things. Increase H-1B quota, visas, etc., etc. I think government, the Ministry of Commerce should seriously think of starting the negotiations with the United States on the free trade agreements. It will be a win-win situation for both countries. Apart from this, In these days of difficulties, I see a lot of opportunity for Indian exporters. Just look at the total imports that are made in the United States from Canada, Mexico, and China. It will constitute totally more than 70% of the total imports into Europe. And these imports are going to be costlier. If only we can sit down today, find out the commodities where imports have to take place more in the United States, and then find out those rates and find out what the demand and supply there. It's high time for our exporters to start manufacturing, exporting there at very high prices, competitive prices. So in these days of difficult days, there are enough opportunities for Indian exporters to export. What we as lawyers should do. We always think the problem comes to us, we go and litigate in the court and succeed and come back. Yes, that's important role for all of us. Revenue bar is there. I'm sure that all of you are involved in this. Remember, before 1947, lawyers played a very heavy, big role for the freedom struggle, for political freedom. The time is now for us to ask for economic freedom. And lawyers are the best brains. They can do so many things. They can think so many things. And they are the people who are assisting the courts to lay down the law, to expand the scope of the fundamental rights dynamically. We are all able to breathe fresh freedom because of the lawyers who did tremendous work night and day, toiling and arguing cases. The lawyers have different role also, apart from arguing the case when the matter comes to you. Constructively, can we think of creating a group of lawyers who will do extraordinary research and advise their clients? Sir, we can do like this, we can do like this. Of course, it requires tremendous amount of study, economics, political, law. Is a combined things, including the demand and supply in different countries. And what is the available resources in India? What type of products can be exported? I think it will be a human service which India can do, lawyers can do, apart from what they do in the courts. I think it is necessary for us to do so. While we are talking about exports on this particular subject matter, we also need to look at export of services. Various companies all over the world are established in the GCCs in India. And definitely gives a lot of employment to us. The economic power of the people who are working in this and then supporting them is phenomenal. While on this subject, we must also step back and then say, are we doing everything fine or we can do something more? We as a country, we are happy our engineers and doctors and innovators are working for many foreign companies, innovations and inventions. And these inventions are owned by those people who are paying salaries to you. And those inventions are patented and sent back to India for getting license fees. And then Rajman will say whether TD is applicable or not, how much pay, etc. That's what we are doing as lawyers. But how come, what can be done for creating inventions in India, inventions stay in India and get the license revenues here in India? That is why the creation of wealth. And again, lawyers can do a wonderful job in this. Joint collaboration, joint ventures, joint ownerships. These are the concepts which you need to necessarily think. And then you connect the fiscal policies. I know what I am talking, some of you may feel not relevant. Hey, I'm revenue bar, why are you talking about all those things, etc. Sridhar, I hope you don't mind. This is, I am trying to expand the scope, ambit, and the power of revenue bar. You can do so many things. And what we are doing till now is infinitely small than what you can do. You may think I'm provoking you. I don't mind being called provoking you. Please. The power of lawyers should be unleashed. And whatever help you need from me, I'm more than happy to help. No problem. I can understand. I can go on talking. I do not know. I think, hey, Vishwadhar, when should I stop now? I think time out. 10:18, right? When should I stop, sir? Because I do not know when to stop. That's the problem. I'm not able to hear you.
Am I audible, sir?
Yes, okay, yes.
10 more minutes you can talk, sir.
Oh, 10 more. I thought I must stop in 2 minutes or so. Any case, so while on this subject, as far as services are concerned, cross-border services, how do they happen? There are 4 modes. Mode 1, Mode 2, Mode 3, and Mode 4. Mode 1 is where the service provider is sitting here, service recipient is outside, render the service moves and not persons. Like lawyers giving a legal opinion to a company in Amsterdam. You are giving an opinion from here. You have not moved. The service has moved. You received money, so it is an export. The second, you go there, render the service and come back. The second, mode 2. Third, people from there come over here, enjoy the services and go back. The medical tourism or telecom, people come here, they use the telephone. During the time when they are here, they can enjoy. Hotel facilities, tourism, all those things come out of that. And the last category is physical presence. You go there, establish a company there, and start rendering services. In all those cases, they are all treated as export under the WTO. And service tax law, they have got their own problems. We will bring in a concept of intermediary, and then we'll intermediary sitting here, therefore not export. We have complicated life. I'm telling you, our life would have been simpler for many ways if only our bureaucrats can coordinate and cooperate. Today we have said so many things. I suppose the new tariff and income tax bill which have been presented or going to be presented will make the life a little simpler, which I don't have my high hopes, given the way in which it has been done so many years. My point here is the export of services is a very, very different concept. And if India can harness the power of the service providers of India, that's something which is unimaginable. And we don't have to worry at all about visas, etc., etc. We're not worried about anything else because people need our services. So that is the second line which we are talking about to exports. And the last one about heal in India, I was talking about. It is now come here, get better and go back. And so many facilities are going to be given, including the visa relaxation for the patients and their attendants. And that is also going to be a huge foreign exchange journey. India is focusing on that. I think, Sridhar, I must give some time for them to ask some questions, right? If I just go on talking, it's not correct. So the next 5 minutes or so, if any questions are there, I can probably. I'm sorry, today I did not discuss any of these provisions of the direct tax, indirect tax. Though my hands are itching, I wanted to, but because Sujit and Raghavan are there to discuss those things very competently, so I'm not addressing. So any questions on this, but I would like to take.
Any questions from the audience?
Morning, sir. My name is Kurkar Vijay Kumar. I work for Madras Management Association here. Able to hear me, sir? It's a very
I can hear you.
inspiring talk. My question to you, sir. We heard so much about C-bomb and EUDR, and I think is it going to impact the business of India if we don't really follow the C-bomb and EUDR? And what your view? How should we negotiate this with European Union?
Very good question, Vijay Kumar. CBAM is carbon border adjustment mechanism. Unlike in the case of the United States, who brazenly said, I will do this, European Union does everything subtle. They say that because of their commitment to Paris Convention, that bringing the carbon emission reduction to a particular level by 2050, whereas we got 2070 at that time. So therefore, they are asking their companies to reduce the carbon emission, and for which they bring in carbon trading, etc., etc. And now they say, because I am now asking my companies to follow the carbon emission standards, if I allow the goods from other country where this is not being done, there is something called carbon leakage. That is, the European company will be tempted to go and establish elsewhere, and Europe will become bankrupt. So therefore, to bring in parity, they say we will impose what is called a CBAM, that is carbon border adjustment mechanism, whereby imported goods, depending upon the carbon emission used in the production of these goods, will be charged to a tax called CBAM. They don't call it as a duty, they don't call it as a tax, it's called a measure, because that's how the European Union, sophisticated language being used. Now, as of now, we are now only to give the reporting. In 2 years' time, the tax will be levied. Now, you asked the question, what we should do for negotiations. We are negotiating. Government of India is negotiating with European Union that we are negotiating free trade agreements. As a free trade agreement partner, you must exempt us or give us longer time, etc. It may happen, may not happen, because European Unions are negotiating very, very strong and tough. How is it going to span out, we do not know. As far as the US is concerned, they have already got out of Paris Convention. Therefore, they can pollute anything. Therefore, typically speaking, all the goods coming from the United States can be imposed CBAM tax. No difficulty. Typically, you are actually seeing it in the wall. Now, as far as your clients are concerned, what you should be doing? Is it good to have the CBAM tax or not? Is the question you must ask. If I were you, I will tell, let the CBAM tax remain, sir. I will adjust my manufacturing program in a manner, I'll ensure my carbon emissions are lower. If that is done, then my export to Europe is now completely assured. The importers in Europe will always be wanting to import from me. So therefore, I get a monopoly. I can charge a price. So therefore, according to you, I'm sorry you asked the question in public, I'm answering publicly. But if you ask me private also, my answer will be the same. Instead of asking for the negotiation for not imposing CBAM, you start saying that let CBAM remain, but let me get out of it. In the olden days, we had the third class in the trains. When I was young, I used to travel. Nowadays, only first and second class is there. In those days, we have third class. And the 2 compartments used to be reservation free. Anybody can enter. And the Grand Trunk Express starting from Delhi will be fully packed. As again 80 people, about 250 people will be there. The train will come to Jhansi and 2 people will get out. And 50 people try to come in. And Raghavan, like heavy, very strong person, somehow or other pushing inside. The first thing he does when he enters, is to lock the door. Same thing. You better be a good third class passenger entering a train. Ensure that you get in and ensure that you get the benefits. And that's my personal advice to you. Officially, yes, the government is negotiating for larger benefit, etc. That's separate questions. I don't know that I answered your question, sir. Vijay Kumar. Yes. I think I should stop now. I think others
One,
must.
Just one question.
Ah,
Sir, I'm Vasudevan advocate.
mhm.
And Trump too, it is America first.
Pardon, sir?
And Trump too, it is America.
Yes.
Here, there's a big push for Make in India. This friendship and economics are naturally not good friends. Do we expect the entire trade agreements with America to be renegotiated with the hard bargaining?
So as of now, there is no trade agreement even started. Forget renegotiation. As of now, the negotiations are concluded in Australia to a great extent. UAE, Oman is almost over. EFTA countries are over, Switzerland, etc. European Union and UK are more in the negotiation stage. Canada suspended because of the political reasons. US have to start. Now, I know US negotiators are going to be tough and they will bargain from a different strength, position of strength. And we are no less. Our negotiating teams are also strong. And we have got enough experience now. So if the negotiation starts, I think we should be able to get a better deal as far as the United States is concerned. And I hope the Commerce Ministry start initiating this dialogue as early as possible.
we have one more question, sir.
Yeah.
Mhm.
My name is Arul Murali Varman, Chartered Accountant from Sivakasi, sir. Good morning, sir. Sir, will there be BRICS currency?
No,
And what will be the advantage for India if there will be a BRICS currency?
no, sir. If don't even talk now, it is a blasphemy. Minute you talk about BRIC currency, immediately 100% tariff. Therefore, just don't know. None of the BRIC countries talk about this. Therefore, you forget it.
Thank you, sir.
Thank you very much.
Thank you, sir. Thank you for joining us today and thank you for your time for that wonderful speech.
Thank you very much, all of you. Namaskar.
I now invite Mr. Raghavan Ramabhadran to address the gathering on the direct tax proposals of the budget.
Sridharan, can I be excused, sir? I'm
Yes, sir. Thank you, sir. Thank you for your time.
A very good morning, everyone. Before very good morning. So Mr. Lakshmi Kumaran, he ended his session 2 minutes before the slotted time. So he was that accurate in his timing. So we used that 2 minutes to set this up. Got a bit delayed here. Someone asked for reduction in income tax rates. So people kept saying income tax rates are very, very high. We want to reduce income tax, reduce income tax. So the promise that has come is we will reduce the number of provisions in the Income Tax Act. No change in income tax rate as such. So income tax book will become small. And that's hardly a week. So it's going to be interesting times. And as Mr. Lakshmanan was saying, that the promise is it is going to be a simple tax. So it's deja vu for us who have been following GST, where it was said that it's a good and simple tax. So once there was some doubt, if income tax is made simple, then what is going to happen? Are we going to go jobless as consultants and advocates, etc.? In fact, there was some discussion yesterday in one of the groups where the safari retreat judgment was being discussed. And now there is an amendment which Mr. Senior Advocate Sujit Ghosh is definitely going to deal with, where the effect of the judgment is going to be completely nullified by an amendment which is proposed in the bill. And that is also retrospective. And Mr. Sujit Ghosh was saying, why are we even arguing in courts at all? So it's like all advocates can now Kumbh Mela time, auspicious time, so you can go and take sannyas. It's what he was mentioning. Then it occurred to me, the slogan of the government is Sabka Saath, Sabka Vikas, Sabka Vishwas, Sabka Prayas. Now Mr. Sujit is adding Sabka Sannyas. So that's where it is heading. In between, there are some good amendments as well. So like Tata Motors says, we also make cars. So there are some good amendments as well. So the discussion today is going to be a lot focusing on the amendments. It is not going to be a policy level, which only Mr. Lakshmanan can speak on. But the opposition says it's a Bihar focused budget. But when I keep reading, I feel it is gift city focused budget. So there are different perspectives there also. What I have done is I went through the judgments, went through the provisions, the amendments. I realized that it cannot be comprehensive, this session which we have. So what we will do is we'll focus on important aspects. We will not touch gift city. No IFSC discussion today. So we will not touch that. but we will focus on all other important amendments which have been proposed. This is how we are going to proceed for the day. So, the rate slabs, this is the old new regime. What is there on the top is old new regime. What is there below is new regime. So don't confuse with old regime or new old regime. This is new regime. So that is what we are discussing now. So you can see that arithmetically it is easy. 4 lakh, 4 lakh, 4 lakh, 4 lakh. So 5, 10, 15, 20. So that's how the new rates are. This is the proposed amendment effective from assessment year 2026-27. So 25-26. Now, 87A, according to me, is the important amendment here. Here again, 87A, individual resident whose total income does not exceed 7 lakhs shall be eligible for this 25,000, right? So this has been enhanced. Now it has become 12 lakhs and 60,000. So again, because when the slab increases, this also has to increase, so makes good sense. But what happened was a doubt arose when it was 7 lakhs and 25,000. A doubt arose, what about special rates of tax? Those income which do not fall within the slab. So for those special rates, whether this rebate is available or not. And some association like us, they filed a PAL in Bombay High Court saying that the provision is clear. There is no bar in applying the rebate for the special tax rates, but the portal is not allowing us. So this matter, a PAL was filed and it was vehemently argued before the Honorable Bombay High Court. Bombay High Court ultimately said, when there is no bar in the provision to apply this rebate for the special rates also, how can a portal dictate? And there was a direction to amend the portal to be in line with law. And now in the bill, the law is amended to be in line with the portal. Both are complaints. Now what has been done is a proviso has been inserted in 87A, which says that this rebate is available only to the maximum extent of the tax payable under this slab, 115 BSE. So which means if there is a special rate and you calculate a tax for that this will not be applicable. So there is compliance, but not exactly. There is a slight miss. So that is what has been done in this provision. This again, for us, some low-level safari retreat. One judgment not followed and nullified. Presumptive taxation, here again, 44 BBD. This is a very, very interesting provision because there are a few words which are used here. And if we have done a lot of sales tax practice, we will engage so we will understand the importance of few of these words. It says non-residents engaged in business of providing service or technology in India. Now, this applies to those services or technology provided by a non-resident to a person in India who is proposing to set up some electronic hardware manufacturing or something connected with it. So this is the basic provision. So in that case, there is a presumptive rate of 25%. 25% is deemed to be his profit. On that, there is a tax rate. So the memorandum says effectively it is not even 10%, it is less than 10%. It's a beneficial amendment. So far, so good. Now, how to determine whether a service or technology is provided in India? So this applies only when a service is provided in India. So how to determine whether a service was provided in India? How to determine the locus for an intangible like a service? The provision does not deem when a service is deemed to be provided in India. It doesn't say. So suppose there is a consultant sitting outside and giving extraordinary engineering consultancy on how the manufacturing setup has to be installed here in India. And then he sends everything through email, brilliant drawings, etc. And then the company here receives it. Is it a service provided in India? So how do we determine that? And this is again a non-resident. So when are we going to tax him? How does it operate for a non-resident? So because still, if you see, this provision is notwithstanding section 28 to 43A, 43C. So therefore, this is not notwithstanding 44DA. 44DA is still there, where a permanent establishment is here in India, and it is for FTS or royalty. If it is FTS for royalty, then there is a presumptive taxation already under 44DA, and this provision is notwithstanding 44DA. So therefore, if we have to harmoniously read 44BBD with 44DA, then we understand that this is for those businesses or income which is not towards FTS or royalty. That is one understanding. Or a permanent establishment is yet not constituted in India. So that is the understanding we get. So therefore, here when it talks about engaged in providing services in India, maybe it is not a service PE we are talking about. So it is not a service PE, but service provided in India. And more importantly, it uses the word engaged. Engaged means there is continuity and regularity, not a one-off activity. Engaged in business of providing services in India, then this provision will get kicked off, and it is notwithstanding 44DA. So there are going to be interpretation issues on when this will apply or when 44DA will apply. These issues arise out of this provision. Now, this is not an option. It is not saying that if you want, you go under this method, otherwise you go under normal. No, this says this is the provision. So if you are engaged in this, you are. So what is meant by service provided in India? Should the actual rendition of service provided there received here, is it rendered in India? What is the meaning of term engaged? So all these questions will arise in this. Now there is a tonnage taxation scheme, which is, I want to take this up.
Yeah. So this is a presumptive taxation scheme which was earlier available only for seagoing ships within India. So it was, the tax was not based on the usual the slab rates or the based, it was not ad valorem, not based on a particular quantum of income, or not based on a particular rate on the income. It was based on the actual tonnage which the ship can ideally carry. This provision is now extended to even inland vessels which are registered under the Inland Vessels Act. So they can also take the benefit of this presumptive taxation scheme. So that's just to support the domestic industry in the context of
More
inland
like
vessels.
what we call as a composition scheme,
Yeah.
or other things. So we don't go with the actual income, but now this has been extended to the inland vessels as well. Now, alternate investment fund.
Yeah. So now this is an interesting amendment with regard to this category 1 and category 2 AIF. So if you look at the income tax law, with regard to this Cat 1 and Cat 2 AIF, they have a pass-through status. So any income other than business income is taxed at the level of the investors. Business income is taxed at the fund level. So now, assuming a fund receives a 10 rupee of income, and if that 10 rupees in the nature of interest, dividend, capital gains, business income, in the same proportion, the income would be distributed to the unit holders. Any income other than business income would be taxed at the unit holder level. The business income will be taxed at the fund level, and exemption would be given to the unit holder. Now, naturally, going by the main objective of AIFs, they invest in securities, they trade in securities, and they make profit out of it. Now, the age-old issue of transaction in securities, whether it is subject to capital gains or whether it will be taxed as business income, still had come into this particular industry as well. Though CBDT had issued circulars in the past stating that in the context of listed securities and unlisted securities, assessees had the option to treat it as capital assets, but still, tax department wanted to tax it as business income because they could earn more revenue if it had been taxed as business income, say at 35%. Had this been capital gains, long-term capital gains would have suffered a lower rate of tax, maybe 12.5% as per the new previous budget. Short-term capital gains would be under 15%. So now there is a welcome amendment to the taxpayers, especially the unit holders, because the investments made by the AIFs in securities are treated as capital assets, and any income arising from the sale of such securities will be treated as capital income chargeable under the head capital gain. So all these incomes will be subject to tax directly in the hands of unit holders at the rates applicable to capital gains. So indeed, a welcome change for the investors.
Now there's another important amendment. Very nice. So naturally a welcome amendment for all of us. So now see this. Section 9, deemed to accrue or arise in India, business connection is required to be there. Now, mostly according to me, this is going to be only very relevant for non-treaty countries. So not for mostly with treaty countries, because we have the permanent establishment concept there inbuilt into the treaty, and that is going to be applicable. This brick and mortar test is going to continue. But here, the deeming fiction not applied to a non-resident, the operation in India confined to purchase of goods for export. This is the crucial expression. So non-resident is there, he purchases goods in India for the purpose of export. Now, in that case, significant economic presence constitutes business connection in India. Now, we are talking here about an explanation 1 versus explanation 2A in section 9. Here, 1 will say that deeming fiction should not be applied if the operations of the non-resident are confined only to purchase of goods in India for the purpose of export out of India. Okay. But 2A will say that any scope for a non-resident to fall within the ambit of SCP on account of purchase of goods. So it talks about purchase of goods, property, many things. So even if you purchase goods, it will qualify as significant SCP in terms of 2A. So apparently there is a conflict. When we talk about purchase of goods, there is a conflict between explanation 1 and explanation 2A. Explanation 1 says it won't constitute significant economic presence. 2A will say it will. So this kind of an anomaly was there. Therefore, there is an apparent conflict with explanation 1. Now, the proposed amendment says transactions of purchase of goods in India for the purpose of export will not constitute significant economic presence at all. So now this has been clarified, and the conflict between explanation 1 2A has been now ironed out. Now the confusion is not there. This has been made effective from 1/4/2026. But this has been made effective from 1/4/2026. What will happen to the period before 1/4/2026 for all these years? That is still going to be a problem. And this problem is now, in fact, highlighted by this amendment itself. So the amendment is itself creating a dispute that there is a definite conflict between one explanation and the other. So this is going to be another, according to me, a burning issue in the days to come.
So non-treaty countries would be Paraguay, Isle of Man, Seychelles, etc. So India does not have a proper tax treaty unlike other countries like UK, USA.
This unit-linked insurance policy is another problem which was there inherent in the provision that is sort of ironed out now. So the principle we have to keep in mind is the exemption under 1010D. Okay, whenever for the sum which is received, the maturity benefit of an unit-linked policy, whenever we receive it under 1010D, exemption is there. If the exemption is there, then it has one treatment. Basically, we are talking about characterization, whether it is capital asset or not. Now, if you see this, policies issued prior to 1st February 21 exempt under 10D if annual premium does not exceed specified percent, let us say 10% of the sum assured. This is one condition. Then exempt under 1010D if annual premium does not exceed 10% of sum assured or aggregate of the annual premiums paid is less than or equal to 2.5 lakhs in a year. So these are the two conditions, and there were provisos for this. ULIPs are not exempt. Suppose if condition 2 is not fulfilled, that is, let us say annual premium is not less than 2.5 lakhs. So the condition is not satisfied. Therefore, 1010D exemption is not available. Then 1010D exemption is not available because you have not satisfied this condition. The categorization will be that it is a capital asset. Therefore, that amount will be taxed as a capital gain, right? This is also a condition in 1010D. If this condition is not satisfied, then it is capital asset. On the other hand, if condition 1, that is annual premium is more than 10%, etc. If that is not satisfied, then it will not be treated as capital asset. So it is silent. So once it is silent, it will become income from other sources. So within 1010D, if one condition is satisfied, it will become capital asset. But if the other condition is satisfied, it will not be treated as capital asset. It will become income from other sources. There is a definite anomaly. What is so important about the fourth and fifth proviso in 1010D? While 1010D itself has 1, 2, 3, 4, 4 conditions. Then there are provisos. If the proviso is not satisfied, it will have one impact. If the main condition is not satisfied, it will have another impact with respect to categorization. This again was an anomaly. This has been taken care now. Now the provision says, if for any reason, read the entirety of 1010D, not just the fourth and fifth proviso, read the entirety of 1010D. If the ULIP, the maturity benefit out of the ULIP is not exempt under 1010D, then it will be treated as capital asset. There is no question of income from other sources. This is what this clarifies. So basically, after this amendment, you need not worry about which clause of 1010D. Once 1010D benefit available, not available. Available, then no problem, it is exempt. Not available, then it will be treated as capital asset. That's all. There is no categorization within 1010D. That is the importance of this amendment.
So just to add on, interestingly, what is to be noted is under section 2, which defines income, amounts received under the unit linked insurance policy is not specifically added as an item of income under 2. Especially whenever a legislation wanted to tax something which is otherwise not an income, they will make two things. Make an amendment in section 2 to the deeming fiction of income, and then introduce a charge under any of the specific heads. With regard to ULIPs, when in 2021, when it was deemed to be treated as capital gains, a charge was already created for a capital gain income under section 2. So they just had to amend the provisions relating to capital gains. But if it had to be taxed under that other sources, whether it is an income at all in the first place is still a question during that particular period. An argument worth trying to explore, but definitely you will envisage a subsequent amendment nullifying it. But
For the new bill or after the new bill?
depends on when the matter reaches the court.
Okay. Now, charitable institutions, there are 3 main amendments in this. One is the larger validity of a registration. 5 years has been extended 10 years for certain charitable institution. This is number 1 amendment. Second thing is what is meant by a specified violation. Some small point is addressed. Then third is about the relative concept. It is there. About the relative concept. Now, on the first point, if the taxable income for a charitable institution is less than 5 crores, not just in this previous year, but the preceding 2 previous years. So in the previous financial years, if it is less than 5 crore, then the validity with the registration which they have, which was hitherto 5 years, it will be 10 years. So it will apply to new applications or whatever pending applications for everything, extensions for everything. This is applicable. So if it is less than 5 crores, then validity is not 5 years. It is increased to 10 years. So this is number 1. Number 2, this specified violation. In fact, this part even featured in the Honorable Finance Minister's speech itself, that where there are violations, where they can cancel the registration of the trust. One of the violations which is mentioned is you wrongly fill the application. So that has been catered to. Now that will not be treated as a specified violation for the purpose of cancellation of registration. So that is number 2. Incomplete application or wrong filling of application. Now the third one. Here again there was some problem because exemption under 13 is not applicable if any portion of the income applied by the charitable institution for the benefit of persons referred in section 13A. So there are some persons mentioned. So let us related person. Now in that, what are this thing? It says if a person has contributed 50,000 rupees during the previous year, then he will be treated as related person. Then what will happen? A relative of such person or any entity in which that person who has contributed 50,000 has a substantial interest, those 2 entities or that person and the other entity will also be deemed to be related, and therefore you cannot the application is barred when it is paid to them, etc. Now, we will know to some extent when a person contributes 50,000. When he contributes 50,000, will you have his family tree with you to see whether who are all his other people, whether this is correct, this is wrong? Will you call for legal aid certificate? Do we do all these things? How do you know if the other person to whom we have made some payment, let us say, whether that person is related to this person or not? So therefore, this was creating some practical difficulties. And another thing is even better. If that person has a substantial interest in some other entity, then any transaction with that entity is also barred. So when even blood relatives, it is difficult to find out. We cannot say, our soil requires, so I won't make the payment to you. We can't say that. So how will we know that that other entity where we are doing some business with, whether there is any substantial interest or not? So these were not making much sense. So this has been taken care of in this amendment. Now it says person who contributes 50K made 1 lakh during the previous year or 10 lakhs in aggregate up to the previous year, then he will be a related person. But a relative of such person or an entity in which he has substantial interest, those will not be treated as related persons. That has been omitted. This is the amendment which has been made. So I think this has been brought to a rational level where we only talk about that person on and not a relative of that person, not a relative of relative. Then income from house property. So we all know this deemed let out concept. So, and also we have a situation in 23 where I have a self-occupied property, but I have a self-occupied property, but that is remaining vacant because my occupation is some other place. Therefore, I live in some other place. Therefore, what will happen to this house, my own property? It will be deemed to be self-occupied. That is the provision we have. Now, there it says for occupational reasons, etc. So, therefore, I am traveling in some other place, living in some other place. Then only this property will be treated as self-occupied. So, therefore, the reason when this property can be treated as self-occupied is very, very specific because of occupational reasons, etc. Now, that has been done away with. This says could not be occupied for any reason. So, it is not only for occupation you are not there. If it could not be occupied for any reason, then it will be treated as self-occupied. And again, the benefit under, I think, 23(4), where it talks about 2 houses, that also remains. So now 2 houses can be treated as self-occupied by us, and this can be for any reason. This is a very important amendment. So the long and short of this amendment is, if there are any amalgamations in pipeline, please do it before 31st March 25. Now itself, now do it now itself. And if you don't intend to, now please plan to. So the logic behind this is the provision so far, 72A and 72A. What happens is there is a loss-making entity. And that loss-making entity is taken over by another entity. So there is an amalgamation. That loss-making entity, let us say they were carrying forward their losses for 7 years, etc. Now, when this amalgamation happens and that loss is brought forward into the new entity, then the new entity can carry forward this losses for 8 years. This 8 years is reckoned to be reckoned from when is the question. There the provision is clear. It has to be reckoned from the date of amalgamation. So from that date for 8 years. This the government sees as evergreening of losses, like grandfathering here. Now this is evergreening of losses. What the provision has done is, already it was lying as loss in some other entity. You have taken over that entity only. Now you are getting a fresh period of another 8 years. How can it happen? So I won't agree. So what they have done is, that loss-making entity, when it is amalgamated into a new entity, in the new entity, you can carry forward the loss only for the unexpired period. So therefore, your period of reckoning 8 years will start from the old entity itself. You should start calculating from that. So another situation, suppose I take over 2 entities. One has a carry forward loss of 7 years, other has for 3 years. Now, date of amalgamation is 1/4/2026. What will happen? You have to see respectively. So therefore, this amount of loss, 7 years, that amount of last 3 years, you have to maintain that, and that's how you have to carry forward. That's what my reading of the provision says. So this is what this provision is. This talks about evergreening of losses. So once you see that there is something evergreen, okay, it must be good. No, they are avoiding evergreening of losses. So this cannot be done. And the provision is effective from 1/4/25 for amalgamations affected on or after 1/4/25. Therefore, there is a real urgency now. NPS Vatsalya scheme, will you?
So now in 2024, NPS Vatsalya scheme was launched by the government. So wherein parents can take pension support for their minor children. So the deductions for the payments made to this, contributions made to this NPS scheme was not earlier available. So now they have brought in a provision under 80 CCD to enable the parents to claim deduction in respect of the amounts contributed. But what is important to note is, under the new regime, 80 CCD 1B is not one of the enlisted item of deduction. So if they want to avail the benefit of deduction, they will have to fall back to the old regime, which is going by the rate structure, it's not lucrative. So that is, so with regard to deduction, not sure how this amendment would be beneficial to the assessees. But when it comes to the partial withdrawal, because if they want to withdraw the amounts for any contingencies like medical or education purposes, so any amount not exceeding 25% of the contributions is exempt under section 10(12)(BA). And similarly, any amounts received on the death of the minor is again completely exempt. So with regards to the receipt, yes, there is a benefit, but with regards to the contribution, to say that there is a beneficial amendment, I doubt at this point in time to call it a beneficial amendment. Depends upon how the tax liability pans out based on the new regime and old regime.
Thank you. A rationalization of rates of TDS. So we have basically a table. So this is what result has been done. Anything specific in this I can deal with, otherwise I don't see much of a challenge in this, except that 194I has a lot of concentration now because it was only 2,40,000. Now the provision says 50,000 per month or part of the month.
So it says 50,000 per month. So when the finance minister explained it, she said 6 lakhs. So if it is 1 month 60,000, next month 40,000, for the first month you have paid 60,000, TDS would be applicable. So the provision is not where it has aggregate 6 lakhs, but earlier it was aggregate 2,40,000. So that's the difference.
Oh. And you can explain on part of month also. Now, any doubts on this? No. 184, right?
Yes.
Exemption limit. Similar amount. So that TDS is also not there. You are talking about old regime. Correct.
Yeah.
Okay. I thought you were talking about exemption limit. Yes. Now, this liberalized remittance scheme is, I think, remittance scheme, this is a welcome amendment, definitely. Because earlier, if you see, there was a threshold of 7 lakhs, after which the authorized dealer has to collect TCS. TCS applicable on amount exceeding 7 lakhs. TCS at the rate of 20% on remittances, other than education and medical treatment. Education and medical treatment alone had a lesser rate of TCS, which is 5%. Then at 1.5%, if that amount which is getting remitted is out of a loan taken from the specified financial institution. This is what earlier it said. So you can see that there is a 20% normal, then 5% for education medical, and within that there is a 1.5% if that education loan, if that remittance is out of an education loan taken from specified financial institution, these three. Now what they have done is that 7 lakhs has become 10 lakhs across the board, no difficulty. Now, with respect to the remittance made out of the loan taken from specified financial institution, that 1.5% TCS which is there, that is abolished. So basically now we have only 2 slabs, 10 lakhs that is 7 lakhs has become 10 lakhs. 10 lakhs is the slab. Now 20% is the rate for other than medical and educational, that remains. Education, medical, 5%. Then if it is out of loan, no TCS at all. So that is the present position. So therefore, no TCS at all when the remittance is out of the education loan is the welcome amendment. Other welcome thing is 7 lakhs has been made as 10 lakhs.
This is only for LRS and not for the tour operator payments.
Hmm.
So that still continue, that will still have the whole threshold of 7.
Correct. 206C 1H, this is again, we have this 194Q versus 206C 1H, both talks about sale of goods, 50 lakhs limit, then which one? Finally, both were ending up, one was collecting TCS, other was deducting TDS in the process, twice the amount was going to the coffer. Though the provision said 194Q will take precedence, all these things practically did not happen. As we know, the supplier, buyer, all those difficulties are there. So now this has been, according to me, rationalized. What they have done is 206C will not apply from 1/4/2025. Therefore, it is only 194Q, which will be there from this period. The other one is this again. Saw the other day in Madras High Court, this was fiercely fought. This non-filers are there. So therefore, how do I know when I deal with them whether he is failing or not failing? So all these debates were there. I don't think there is a final order yet on this point. So now I think it has at least reached the ears of the government. So where they have said higher rates of tax deduction and collection under 206AB or 206CCA, if the person, the other side, is a non-filer. This was the provision. Now this has been omitted. Both have been omitted from 1/4/2025. So therefore, earlier you have to get into that compliance portal, what that inside portal or something, see whether he has done. All those problems are now postponed for a week. After the new law comes in.
So, but the non-linking of PAN and Aadhaar, which makes the PAN inoperative, that continues to have a higher rate of TDS. So because that's coming from a rule which says that it is as good as you have not applied for a PAN. So you don't have a breather for that. So this non-linking of Aadhaar and PAN, where the PAN becomes inoperative and the rule specifically deems it to be a case of a no PAN. So again, for that higher.
You don't expect an amendment in the rule.
Definitely not.
Decriminalization of TCS. No, I'm sorry for the heading. It's not decriminalization of TCS, not So collection of TCS and non-deposit thereof considered as a serious offense. So TDS also is there. Now what has been done is in 276BB, in line with earlier itself it was done for 276B. Now it has been done effective from 1st April 2025. The ultimate thing is month on month you are supposed to deposit. Then quarterly statement you have to file. So month on month you collected but not deposited. You can wait for a quarter end. After the quarter end, before you file the statement, by that time at least you deposit. By that time also, if you don't deposit, there is no decriminalization. Then there is criminalization. So therefore, it is only the 2-month breather which is given, and it has been brought in line with the earlier amendment. Updated return is very interesting. If I remember right, the memorandum for this says this is to nudge taxpayers towards voluntary compliance. This is what it says. Let us see whether it nudges them or helps them fudge. So, updated return can be filed up to 24 months. This is the present scenario. Rate of additional tax within 12 months, if we disclose and pay, then it is 25%. Between 12, after 12 and before 24, then it is 50%. This is the present position. Remember, this 25% is additional tax. This additional tax is calculated on the normal tax plus interest thereon. So it is calculated on interest also. That is the provision. Now the proposed amendment, which is effective from 1st April 2025, is the time limit has been enhanced. Earlier it was 2 years. Now it is 4 years. Up to 4 years you can do. No updated return can be furnished if 148A notice has been issued after 36 months from the end of the real investment. However, If the order is passed, so first of all, if 148A notice has been issued saying that for you, it is beyond 3 years. So that scenario, 5 year scenario where you have not disclosed, etc., then in that case, you cannot go for this. But that notice has been issued, you fight it, subsequently it has been held that beyond 3 years is wrong. Then you can still avail this. So basically it is saying that it is not for people who have suppressed willfully, etc. It is not for those people. So that is the effect of it. The new rates is like this. If it is within 12 months, 25%, 12 to 24 months, 50%, 24 to 36, 60, 36 to 48%, 70%. That is your normal tax, then normal interest. Then on that, this tax, is there interest for this also? So, so this is only proposed amendment. That you will see in new DPC. I was calculating yesterday. Say, let us say, for example, 2023. Now, for that period, 23-24, the person files in 27, 1st April 2027. So he has crossed 3 years. Then let us say he is in a slab of, let us say, 1 crore. Let us say 20 lakhs somehow got missed. He wants to, he finds out himself. He finds out and then says that maybe some expense wrongly claimed or he realized later, but he realized by himself. And then he says this 20 lakhs doesn't belong to me. Earlier, what you would have, whenever he would have come, we would have said assessment over, assessment not over. In case write a letter, we want to be always on the right side of law. Therefore, write a letter to the department, say, because revised return time period is over. So tell them that this somehow got missed, I am ready to pay the tax. Fine. That was not nudging. Now this is nudging. How do they nudge is, they ask you to pay, now you have crossed 3 years, okay, let us say 60%. 60% of tax, already one tax is there, that is your 30% slab for that, 20 lakhs, 30%. On that, that is, let us say 6 lakhs, then there will be a surcharge, that will be what, 15%, 10%. Then there is a 4% cess, that is all separate. Third melodies are sweet, those unheard sweeter. So those are also there. After that, then calculate interest on this, on that 234C, B, etc. will come. So that will come to around some 40%, 41%. Because 3 years, 36%, then this comes to some 5.05%. If you calculate, that will come to 41%. Then add these two, on that you calculate 60%. Then definitely crosses 20 lakhs. 100%. Easily crosses 20 lakhs when you calculate that. How is it even voluntary compliance? I do not know. But if anyone wants to do that, you can suggest this what they can do. Other amendments, 278, you want to do?
So 270A is dealing with immunity from imposition of penalty. So now when an order is passed and you want to claim immunity from penalty upfront, so you can pay the tax along with interest within the due date and then write a letter to the AO asking for immunity. Earlier, AO had 1 month to pass the order of granting immunity. Now the time limit has extended to 3 months. So
Yes.
not time limit to complete penalty proceedings. So earlier you had different rates, different timelines for completing passing the penalty orders, depending on where the matter is at the stage of AO, at the first appeal stage, or the second appeal stage, or the revision stage. You had different time limits. So apparently it was creating an administrative inconvenience to the department to find out the actual time limit and complete the proceedings. Now they have kind of rationalized saying that every penalty order should be passed within a period of 6 months from the end of the quarter in which the assessment order is passed, if that is not appealed against. If the order is an appeal and appeal order has been passed, if once the appeal order is received by PCIT, so on and so forth in the case of revision. But one thing to note is this amendment is effective from 1st April 25. There could be some cases where the timeline would have lapsed under the old law. Now, because of the new law, can you extend the time limit? Now we have the age-old decisions of Uttam Steel, etc., which says that law cannot revive a dead right. So as and when it comes, we'll have to test how those propositions will still continue to hold good.
No, when you say this reminds me, going back to that updated return, I was taking a case of 3 years, that is over. After which I am disclosing myself. By that time, the period for assessment would also have been over.
If the income is less than 50 lakhs, period of
50
assessment.
lakhs. Period of assessment is also over.
But your prosecution proceedings can be
That
initiated.
is okay. So, I mean, I meant I understand. What I'm saying is when I'm going and disclosing all.
Yeah, that's there.
This transfer pricing, block assessment is not the term used in the provision. So we are just writing block assessment because there is something mentioned in the memorandum. What they mean is for a particular year, suppose we determine the arm's length price. It is determined. There again, some clarity is required here, but whatever is there in the provision, we await the rules, whatever we can understand based on this. This says that whenever we have determined the ALP, got the ALP determined, and then that is there, the option is there for the assessee to apply to the officer and then say that ALP can be adopted for the consecutive 2 assessment years also. So every year you may not do the same process. You can apply and then say that this ALP may be applied for the subsequent 2 financial years also. So on the face of it, I saw and said fantastic amendment because we know the ALP for 1 year, we have gone through the process. It is a similar transaction, so transaction almost remains the same. So all parameters, as we say, ceteris paribus. So we tell the officer, sir, same thing. So next 2 years, fantastic. I may take a hit, I may not. Suppose, let us say for the first year, we have calculated, say, a profit margin of 15, and that's how it is calculated. Next year, it may be 18, I may benefit, but the next year, it may be 10. So overall, it evens out. But after this, there is another subsection which is also introduced, which says that after we apply and we opt, officer will see whether that ALP is right or not, and then he will redetermine. So then it is the same as what is there already. So if we are saying that if ALP is determined, you don't need to go through this whole process, and then you can opt and tell the officer that for the next 2 years also you can adopt the same thing. Officer also agrees. Then the subsequent provision says, but officer will also look into it and then see if this ALP is acceptable or not. Then he will determine ALP. Then Parthi Mutta Godownle irundirukkalam. It is the same thing. So this is what the provision says. I hope the rule gives us some clarity on this. And it also says an option. I've also seen if it is an option. So first year, let us say 15% was there for the first year. So next 2 years, I want to adopt. Next year, I broadly know it is going to be 20%. So I will say, so let it be 15%. But for the third year, I realize it is going to be, for the second year, let us say it is going to be 20%. So I say that 15 is better, I will opt for it. Third year, I know it is going to be less. So if I go for this method, they are going to apply 15. So can I opt out? So it says I can opt. It will be applied for 2 years. It doesn't say once the option is exercised, it is final. It doesn't say it is final for 2 years. So for the third year, can you say that option I applied for last year, I withdraw now? Can we say that also? We do not know. Let us see. Because it is not saying option once exercised is final for these 2 years. Clarification regarding period of sale is basically exclusion.
Exclusion of the time period. So with regards to the stay proceedings, so many provisions said the period during which the order was stayed was excluded from computing the time limit. So earlier, apparently there was an ambiguity as to how to determine this time period. So now they have kind of clarified saying that from the date of commencement of the order passed, order granting stay, till the date on which the order is received by the PCIT is the period you will have to exclude. Maybe
That date which we'll never know. We will
earlier,
never know.
maybe we could have excluded from the date of the order granting stay till the date of order which passed vacating the stay, the date of order vacating the stay. Maybe that interim time period of.
Correct. What I'm saying is with this amendment, it is the date when the PCIT receives the order, which you and I will never know.
It's kind of a beneficial amendment to the department, I guess.
That is what we have been seeing all through. Extension of dates. I'm not dealing with this. Basically, 2025 made to 2030 in many cases that we have put in one place. So with this, we come to the end of our session. If there are any questions, I can take right now because I know Mr. Sridhar Ghosh is waiting, but for 5 minutes or so, if you can take. Yes, sir.
So in 7, which we have been talking about, so the current provisions, things like it will become the loss of the amalgamated company in the year in which the amalgamation was effected. The all provisions relating to set off and carry forward shall apply, which allows us to take a stand that in the year of merger, you can even set off against other rates of income also. So just because it's now going to be carried forward only for the remaining years, so whether the new amendment does it change the position?
So
allowed
there
to
is
set-
no whisper about that restriction. There is no whisper about it. Its concentration is only on the time period. And that is why they say it is to stop the evergreening of the loss, because I think they see it as a situation where many companies are closely held, etc. They just amalgamate only to ensure this loss is not lost. So therefore, that is what it is talking about. It is not talking about what it can be set off against.
Sir,
on-
72A4 vis-a-vis 72A3 and 6 was slightly different because 72A4, which already was saying the loss of the demerged company shall be carried forward and set off. Whereas if you read 72A1 for amalgamation or 72A6, the language was set off and carry forward. So whether alongside this change, are they also trying to restrict in there in which you merge?
Because you are
Uh,
saying I look at it closely. I don't think I have,
Yeah.
I didn't see it that way, but because you are saying there is a definite difference in the language where it talks about set off and carry forward, I will have to look into it.
Sir, one small issue on that, whether the loss will include unabsorbed depreciation also. Because there are some judgments, they are independent. See, you can't, unabsorbed depreciation will be independent of, cannot be considered as a carry for business loss. So what will be the scenario after this? I mean,
Talk only about.
Only about business.
business loss. Then one more thing with regard to transfer pricing. Whether it is applies to all the cases where it has not been selected for, TP assessment by the TPO, or you can so moto go for all the cases. Whether it is selected for TP assessment or not. Whether the assessee can voluntarily go for all the pending, subsequent assessment, yes?
Yes,
Hmm.
assessee can.
Ah.
Assessee can. It is
For
purely
one
the option.
For the year one, you should have, the matter should have been definitely referred to the TPO.
No, the question is for the subsequent. 2 years.
Subsequent 2 years, even if it is not referred, you can voluntarily go. So the provision says it will not be again referred, but again, that's where there is an anomaly.
Any other questions?
Thank you. Thank you very much.
Thank you, sir. I now invite Senior Advocate Mr. Sujit Ghosh to address the gathering on the indirect tax proposals.
Good morning. 11:30. So first of all, I'd like to thank RBA for having invited me. A good friend Ravi called and I couldn't have said no. It's a privilege to be here with you all. I was noticing your presentation, how much pain you have taken to make 45 slides. I'm sorry, I don't carry any slides, so please forgive me for the indiscretion. You know, back in the days when I was growing in the profession, indirect taxes and direct taxes changes in budget used to be like ocean change. Lots of changes used to happen and overnight we used to work, come out with fancy presentations and booklets and whatnot. These days, budgets are not as exciting in terms of the changes that that really takes place. So there's only few things that happens. And after GST, with the GST Council, year round, there's entertainment, right? Some change, some amendment, some rules, etc. So therefore, there's very little that has happened in indirect taxes. I'll put it that way. But whatever has happened, out of that, few are very relevant. So I'll come straight to what I intend to cover. There is a section 130 of the finance bill seeks to provide some changes in service tax law. some beneficial exemption has been given to some kind of people. I really don't understand how. You see, service tax was part of the chapter 5 of the Finance Act, right? That was obliterated, repealed with the GST coming into force. With the repeals and savings, only rights and liabilities were saved. They had a power to make amendment under section 19 of the 101st Constitution Act, Amendment Act, up to 1 year. That 1 year is also gone, 2016 to 2017. So really speaking, the parliament is denuded of any power, even touch anything to do with the Finance Act 2004 or 2002, right? Under that circumstances, what is the legitimacy of this exemption retrospectively that they are granting to some bunch of people under section 130 of the Finance Bill 2025? It actually appalls me. Are they trying to say that no, they still have their residuary power under the 1997 list 1, and therefore they will do what they want? But that also is very doubtful, because when the discussion of subsuming taxes were happening in the parliament, and therefore the GST got introduced to 46A, it is very clear that they have ceded that power to the state as much. So therefore it's no longer into 97 in force. So it's a very surprising change, and it's more academic than of academic interest than anything which will have a day-to-day repercussion. But just think it through, go back to your drawing board. Look at what is the proprietary of section 130 of the Finance Bill in making amends, edits, tax changes to a Finance Act which has been long repealed. It's 7 years now that we have GST. So that's the first thing. Similarly, I see changes in the Central Excise Act. Now, entry 84 has remained truncated to few goods. To that extent, yes, Central Excise Act survives, but the amendment that they have made is in respect of Settlement Commission. They have introduced a new board, right? Interim board or something like that. How do they touch that? Because the Settlement Commission must have been dealing with everything, not only those restricted, those goods that are now covered under 84, but also everything, right? These must be old past cases. So how does the government go and attack or touch the Central Excise Act in respect of those goods which are not part of entry 84 anymore? What is the legitimacy of that? Should the government not answer us in the academic forum? And I wish if somebody from the government here to give us some ray of, because maybe there's some jurisprudence that we are not aware of. Maybe they know their job. So these are the two niggling questions that kind of came to our minds as we were looking at the budget or the changes. I'll start with the customs now. Fundamentally, two changes have happened which are relevant. What used to happen was, provisional assessment was to ensure that some investigation, some screening, etc. happen, and then the goods are permitted to be cleared so that the business does not get disrupted. And in the meantime, all the investigation documents would get submitted and they'll come out with a report and then finally assess. That's the problem that used to happen was in the name of provisional assessment, even though there was a timeline available. What used to happen was the language used to be X period from the date of receipt of the document. And that X period used to be 2 months. Ideally, they should have completed within 6 months. That's what their manual says. That within 3 months, 6 months, you need to complete it, but within 2 months, you need to close it. That's what the statute said. But the catch was 2 months from the date of receipt of document. And what they would do was keep on asking for more documents in a manner such that they would keep on extending the 2 months. So it was a abuse of the provision that the customs would do. The resultant provisional assessments would not be completed for a long time, and people would go to high courts seeking mandamus. It is this menace that was prevailing in the trade or in the customs discharge of the official function, that this amendment has now been made, which now says within 2 years from finalization of provisional assessment, this is the period. It can be further expanded based on sufficient cause. Now, well, that's a leeway that they have, but then they'll have to still show to the court that there was a sufficient cause. It can't be based on some, irrelevant reason, not borne out of the record. So if they say that, no, this document was not given, but the document is actually on the record, then you can't say that was sufficient cause. So you'll have to create reasons, which is defendable before the court. But at least one thing is clear, that there will be certainty of closure within a time frame, which I believe it's a very good provision that the government has brought out. It'll ease business. Now, the second is revision of entry post clearance. Now, this has been a big issue. At least I know for a fact that I've done a few matters in the Madras High Court. You file a bill of entry, and then suddenly you realize that you made a mistake. The mistake would be, a bona fide mistake, would be some classification you entered wrong, or an exemption that was available, you forgot to claim that exemption, something of that sort. So you would go to the Customs Department under Section 149, say that, look, I want to amend my bill of entry. The amendment of bill of entry gave rise to 2 or 3 vagaries. There was a circular issued by the Commissioner of Customs, if I remember right, saying that anybody who comes to switch the bill of entry or amend the bill of entry, not switch, amend the bill of entry, since it's an assessment, you go on appeal. I will not permit you to amend it. They would read the decision of Supreme Court in ITC in a very perverse manner to say that, look, ITC says it is an assessment, therefore you have to file an appeal. If you don't challenge that bill of entry, then therefore you have no. But then ITC also said that, well, any appeal or any other provision known to law, they also used that. And the provision was Section 149, which actually contemplated amendment of a bill of entry. So matters went before the High Court, and High Court quashed that circular. In fact, my colleague was appearing in that. And ultimately, what the law that is settled by all high courts, not only Madras High Court, but all high courts, is that amendment of bill of entry is a legitimate means to change. It, of course, came with a very interesting caveat, and I must read that section. It used to say, save as otherwise provided in section so-and-so, the proper officer may, in his discretion, authorize any document after it has been presented in the Customs House to be amended in such form and manner within such time, subject to such restrictions and conditions as may be prescribed. No rules were ever prescribed. No rule was ever prescribed in terms of under what circumstances he will not exercise this discretion. So it was an open field, and they would abuse it to the largest extent that I know of. Now, this has changed, I would say, for the good. You don't have to go to the customs fellow, invoke Section 149. All you need to do is apply this new section, Section 18, capital A. What it says is that, look, if you file a bill of entry, you want to revise it. After the goods have got cleared from out of charge has been issued, goods have gone into the domestic market, home consumption, etc. You can then revise it. And should you revise it suo moto, then if there's a differential duty, you must pay the interest, but there will be no penal consequences, which I think is a very business-friendly process. No lawyers involved. It's the CHA who will do everything, unless some problems do accrue at that point in time when they're trying to revise it. But it's actually a seriously good initiative that the government has taken of self-revision or a reassessment, self-reassessment, if I were to call it. What will have to be seen is what happens if there is a differential duty in your favor. You paid 20% duty and realized it was 5. Then what happens in that situation? You'll have to claim a refund. What will be the date of refund for that will be computed, because there's a limitation period for claiming refund. Which date will be there, etc. Those niggling issues may come up. Nonetheless, it's a beneficial thing, as I would believe. So these are the 2 important customs changes that have happened. Rates have changed. I did not get into that. What transpires to me is that social welfare surcharge has been knocked off for several items, and many of those items are now subject to an agricultural cess at 20%. So it's a yin and yang kind of thing. They have taken it off from here, they brought it up here. Of course, some tariff rationalization has also happened, but at the end of the day, the purpose for which social welfare surcharge was for the social welfare. Now it is no longer social welfare. Government wants to focus, it probably wants to focus on agricultural welfare. So be that as it may be, the policy shift has happened, and that is what has happened. Nothing big has happened. I'll now go to GST changes and not Safari yet. Most of the changes in GST that I see are all maintenance mode. They're all maintenance mode. They're trying to rectify inadvertent errors, unwarranted hiccups in the implementation of GST. This is what I feel personally. So the first is this concept of, definition of local authority. Irrelevant. Not many people are concerned about that unless you fall under that category, because section 7(2)(b) talks about exclusion of certain bodies from the levy of GST, which is neither supply of service nor supply of goods. There was an ambiguity insofar as meaning of the word local authority was concerned. That ambiguity they have settled by providing a definition. So it's a beneficial thing in the sense that now there is clarity, because certainty of tax law is the most important thing that we all, assessees, lawyers, accountants, we all aspire for. Now there is a certainty of what a local authority means for the purpose of that section. So that's a good measure. There was a huge debate in recent times about taxability of vouchers. Now, our Madras High Court has tendered a judgment, Karnataka High Court has tendered a judgment. All along, the view that has emerged is vouchers are actionable claims, right? There can be no denying about the fact that it's a debt owed for a future transaction. But the tax authorities were confusing, and for reasons best known to them, because it is very clear that the chargeability has to come from section 9 read with section 7. Section 9 is supply, interstate supply, and section 7 is what is supplied. If you do not fall under this, you can't use a machinery provision to create a tax liability. That's a very fundamental basic jurisprudence. What the tax authorities were doing was they were relying upon the machinery provision, which used to provide for time of supply. So time of supply is a machinery provision. There is nothing, no doubt about that. And in that time of supply, for supply of goods and there was time of supply of services, there was a reference that in respect of supply of vouchers, time of supply shall be so and so. They use that to deem that because there is a time of supply prescribed by the legislature qua vouchers, therefore it must be a taxable supply by implication. Obviously, they don't have to do this detailed analysis of whether it's a negotiable, whether it's a actionable claim or not, because that's an interpretive exercise. Who gets into that, and why should they? Why should they build the cat? Let the adjudicating authority, appellate authority, High Court, Supreme Court do that. So therefore, it was an easy way for them to say that, look, section 14, section 15 makes a reference to this voucher, and therefore it is deemed to be taxable. This vagary, this unintended or abuse of the provision by the revenue has been plugged. Today, those provisions have been completely deleted in the finance bill by virtue of section 117 and 118 of the finance bill, which specifically deals with section 12 of CGST Act and section 13, which used to talk about vouchers, time of supply. So it's now a certain thing. Many show cause notices will now fall by virtue of this. Third is more like a hygiene issue for the government. They have come out with what is called a track and trace. Now, you see, border management or goods management in a one nation, one tax is a very critical instrument for the government, because you really don't know what is being claimed as export is actually being exported or not. What is being claimed as manufacture is actually being shifted out or not. Clandestine removal has been a bane for the longest time under Central Excise Act. Now we are in a digital world where there is, portals on the one hand and technology, ASPs, etc. on the other. So this whole track and trace is developed to my mind as a hygiene for the government to take control of the supplies that are happening in respect of which you are either disclosing a turnover, claiming a deduction, exclusion, abatement, whatever else. it's not something that should be looked at as a draconian, because it's a regulatory power to my mind. And why not so? If you don't have scruples, you have reasons to be worried about. If you have scruples, then you have no reason to worry about. It's a good move to my mind, positive in that sense, but they have not expressed who will be covered by that. Such person, such goods as may be prescribed. So we'll have to wait and watch how the central government notifies what will get notified. But it's an extra administrative cost, no doubt about that. But then that's the cost of doing business in India, and we can't be worried about that. So that's section 148 capital A, that they have provided an enabling mechanism for track and trace. And there is a penalty also that they have imposed for violation of track and trace provisions. The next one is Schedule 3, which is with respect to supply to FTWZ. Supply to a warehouse was already excluded within the ambit of GST by virtue of the exclusions. Schedule 3. There was a doubt whether warehouse will include a free trade warehouse. It was a very obvious answer to my mind. But then the manner in which the definition of the word warehouse was, because they would tack warehouse definition to the Customs Act, and Customs Act would not make a reference to warehouse of FTWZ, because that was under the SEZ and allied laws. So this incongruous position that accrued is now set to be taken care of. Now, the status of FTWZ, SEZ is the same as that of a warehouse, and supply to those places will no longer be liable to tax. However, past transactions are not protected, in as much as if there's a refund due, you will not get them. Very smart way of the government trying to cover their track for the past. And we are quite used to that thing. There are some miscellaneous amendments that have happened. ISD, reverse charge mechanism, they have now provided that thing that will also be part of the reverse charge. I don't think we need to worry about it. One thing that has happened is initially pre-deposit norms was restricted to tax and interest. There was a vacuum with respect to penalty orders only. The penalty order was changed to 25%. They came out with the 25%. This year it is now brought to 10%. Some controversy that seems to erupt whether 10% is the maximum or 10% is the minimum. What will happen to that? So we'll wait and watch how this gets panned out. These finishes the bare bone changes in indirect taxes. Trust me, there isn't anything more to this other than some goods changes, tariff change here and there. So therefore, that leads us to Safari. How many of you are interested in hearing Safari? All of them. Some of you. Most of you. So this is not a shocker. We anticipated it because the GST Council did make a remark about it that we will do so in the budget. But the question is, are we really to shed tears now? Are we really to worry about these changes? Has it wiped out everything that we had garnered thus far? It's a mixed bag answer. I'll first give you the answer, then I'll tell you why we are saying it. So, my personal view, insofar as those who have constructed immovable property for leasing, nothing has changed. This amendment does not even touch them. I repeat, insofar as those who were in the business, who had got immovable property constructed or were engaged in the business of leasing, this amendment does not even touch. Not even by a speck of air. They continue to be safe, in safe harbor. Why? I will tell you later. Insofar as those who had their setup and that was used for carrying out further business, namely manufacturing, servicing, etc., they are doomed. Retrospectively, they are doomed. They are not only doomed retrospectively, but whatever benefit that they thought they'll get because of the judgment of Supreme Court is also prospectively not going to be available. So really speaking, there are two competing classes of people in the industry who will wake up to this amendment and view it differently. First are those who have constructed for leasing, namely malls, warehouses, and every other asset which after creation gets leased out. Second are those which are not into the leasing business, but uses it for further manufacture or facility for their own business. Now I'll come to the third attribute of that. Those who are in the business of leasing will have nothing to worry about. They probably need to just shut their eyes off and make good with whatever is available. But those who have been cut off, the non-leasing business category, the question that they may want to ask is all gone, or can this retrospective legislation be challenged? And I'll deal with that aspect also. Can it at all be challenged? And the third part that will be relevant is, are there any other infractions that can be seen by this amendment, which can be brought to the attention of the? So it's a heavy basket of things that I will go through for you. If I'm going too fast, stop me. If you want clarification, stop me there. When Safari judgment came about, there was a YouTube video that was floated where I had made some presentation at some association's program. And I had made it very clear at that time that there were 3 layers to the Safari judgment, or 3 tests to the Safari judgment. The first test is test if you are movable or immovable. If you are movable, then you don't have to worry about this provision at all, C or D. If you are movable, even if those movable things may be descriptively written in the explanation, you still don't have to worry about it. And that explanation that I gave was vindicated by a decision of the Delhi High Court, where I was appearing in the case of Bharti Airtel, where telecom structures, even though it was part of the explanation as the excluded items, because it is movable, it got knocked out of the restriction under the section and credit was available. So that first test that I told had met judicial recognition by a recent judgment. Maybe they'll file an SLP, maybe they will not. That's their prerogative. So test 1 was whether it is movable or not. If it is movable, you completely come out of the restriction. Life is good. If you are immovable, then the second test was test whether you are plant or machinery. Right? This is what was there. And of course, I'm dealing with clause D here, not with clause C. And I said that if it is covered within the meaning of plant or machinery, as explained by the Supreme Court, functionality test, this test, that test, nexus test, whatever test that you may contemplate under the judgment provided by the Supreme Court, then you have nothing to worry thereafter. You are completely out of the sweep. So I said, if you pass the test of plant or machinery, you have nothing further to go into that section. You are completely excluded. Then I said that if you don't pass that test and you are actually plant or machinery, or plant and machinery as they have explained, and you are stuck, then the third test is whether it is on own account or not. If you're not on own account, this provision does not touch you. Even though you may be immovable property, even though you may not be plant or machinery as defined or excluded. So on own account. These are the 3-tier tests that I had said at that time when the judgment came about. What the amendment does is, for whatever reason, I'll come to later, the word plant or machinery has been changed to plant and machinery. Simple, they say it is parity between C and D. Very good. In other words, if you are plant and machinery, you get the credit, but the definition of plant and machinery has excluded items where building comes in. Therefore, you are not a plant and machinery. Right? So far, so good. But then, if you are a plant and machinery, but that is not the end of the story. There's another exception that it should not have been used for own account. And own account has been interpreted by the Supreme Court to mean where you're using it for your own personal purposes, self-consumption, settings where your business is carried out. So if you are not own account, where the Supreme Court says at para 32 that it is actually leasing is not own account, then you're through. So to my mind, reading of the judgment of Supreme Court with this amendment proposed, malls, warehouses have nothing to worry. Make no mistake. And if any authority stands up, please take the recourse of law as known to law. That messaging is very important. Let the government also realize that all is not over. And we must push the government back, which is where I'm going to come to the second aspect of the whole thing. And I say this with full responsibility that, and I was telling somebody the other day in some forum, not forum, private forum, just one sec, put my password down. Why do we even litigate? Why do we even litigate? You succeed after long drawn 5 years of battle, intense battle in the Supreme Court, and the parliamentary supremacy is used to overturn. We heard that Ramabhadran made a mention about some portal issue. And it is not the first time. It is happening successive times. Successive times that SSC succeeds. It is kind of overshadowed by a retrospective amendment with a saving clause. It begs 2-3 questions of the morality of such retrospective legislation. And I'm asking this question to the government of India, to all of you, the morality of this retrospective legislation. I have no doubt in my mind that the parliament has supreme sovereign power to make retrospective legislation. No doubt about that. But when the exercise of that power is done in a manner repeatedly in the last several years, successive governments, to overthrow a judgment of the Supreme Court, even though it may be legitimate legislative action, can it pass the test of morality? How far morality in legislation is relevant is something that we should ask the question as citizenry. Because it seems to me that if there is a ticklish issue, you might as well pay the tax, because 5 years later, that is what the reality is going to be. Why spend money on lawyers? Why have docket explosion in high courts, across high courts? Why get excited by a good high court judgment and then come back home and say, oh my God, 5 years later it's going to be overturned by the legislation, not by the high court, by the Supreme Court. So the question of morality of a retrospective legislation needs to be examined. And in that context, some jurisprudence is there internationally. I will not trouble you with that, where people have actually questioned such motives of the legislative wing of the government in coming out with such retrospective legislation. That is point 1. Point 2. Let us understand what is the effect of the judgment of Supreme Court. Then we'll come to what is the effect of the amendment. The judgment of Supreme Court therefore declared the law. Declared the law as of 2017. Saying that as of 2017, you are eligible to claim credit. Is it not a case that a vested right came to be accrued? Subject to limitation. Forget that for a minute. It's a smaller issue. Is it not a case that a vested right came to be accrued to the entire industry as of 2017, when GST was rolled out by virtue of the judgment of the Supreme Court? And if the answer is yes, we know that Senraj credit, all these credits are all vested rights once you have met all the conditions. Until you have met the condition, it's a privilege. But the moment you have met the conditions, it becomes a vested right. There are judgments galore of the Supreme Court. Once it is a vested right, there is rich jurisprudence in India which says that a retrospective legislation can be questioned if it is seeking to take away vested rights. There is rich jurisprudence in India which says if the retrospective legislation seeks to take away vested right, then that is bad, can be challenged as being unreasonable, and 19(1)(g) can be pressed into service. We're not talking about 14 here. So that's the second important attribute for consideration of this retrospectivity is legality. The third, if you look at the rationale given by the government senior lawyer before the Supreme Court, that to and was inadvertent. He didn't use the word inadvertent. He said that it should have been and. It is a drafting error. That is what was pleaded before the Supreme Court, and it is recorded in the judgment. The Supreme Court examined two things. Examined two things, three things actually. Supreme Court said in the paragraphs, there are 7 or 8 places where you have used and in this one place you have used the word or. So it is conspicuous by its absence. What stopped you from using it the 8th place also? Second, in the draft GST bill that was floated, the model GST bill, they are both and, but you chose to put or in this one and in the other one, which goes to show your conscious legislative action of putting it there. And third, it's been 6 years since this whole litigation has been happening. You never bothered to change it. All of this put together, Supreme Court said, no, it was not a legislative error. It was a conscious legislative action. And that's very important ingredient of what argument or some whatever point of law I'm going to put. A fundamental jurisprudence on retrospectivity is it can be validated if it is found to be curative. A curative action by the legislature can be validated, and the meaning of the word curative is where the legislation was not meant to act in a certain fashion, but it has been abused by the industry or SSE, then you try to curate the position back to what you intended to do, which is called the doctrine of small repairs, where you repair, going back in time, make small repairs to infuse the intention that you had by changing words here and there. Doctrine of small repairs. So curative is a good defense that the government would always put. That it was not the intention. But I say, what you intended or not, the Supreme Court has spoken. Supreme Court has spoken that this was not the intention. If that be the case, can you file an affidavit to say, no, it was still my intention? It was never the intention. Because then what you're saying is that you're trying to re-agitate an issue, res judicata comes into play. How can you re-agitate an issue? Because Supreme Court has spoken that it is not a inadvertent mistake. It was a conscious decision. So even the curative test will fail, to my mind. Fourth point is the length of time. Rich jurisprudence in India, where the courts have said that if it is found to be for far too long a period, then that is not fair. That is not a fair legislation. And here, what have they done? 2025, 2017, 7 years. That, to my mind, is not a short period of time. It's a long period of time. And lastly is the principle of confiscatory. It is confiscatory, no matter what they may say. They speak about parity between C and D, but they don't speak about parity between movable and immovable property. So when it is convenient to the government, parity becomes a relevant reason to justify the legislative action, but otherwise they don't. In substance, I would believe that today it is in a bill form. We have nothing to worry. As yet, let debates happen in the parliament. Let the Finance Act come into force. At that point in time, I think this amendment should be taken to court. And also the point of tax morality of retrospective legislation heartful debate from Harvard, that debate can be brought into force before the courts. It is important now. Because otherwise, SSCs will get steamrolled for years together. And we are therefore going to be only those people who are meant to do small issues like declaration form not given, please rectify, writ of mandamus. Declaratory writs will lose its relevance, especially on sensitive large matters. Of course, if the government wins, no amendment needed. But when the government loses, that is the way to take, get back. Of course, there is a legitimacy in their action. Where is the morality? What is the morality in what to do? So long and short of that is leasing, you're not touched at all. You are in good zone unless they wake up and make further amendment. I should not be speaking too much, lest they get some air and wind, make further amendments. That will only make them look so very, very strange. Second, for those who are not into leasing, you have a problem. Think about retrospective challenge and also prospectively apply doctrine of, I'm not doctrine of, for the prospective thing, you apply F19 because what had happened was Article 19 was not even pressed into service in Supreme Court. The whole debate was on Article 14 and I am to blame because I argued Article 14, I did not argue 19. Now, the reason why we can't argue 19 is unless a petitioner says, I'm going to put a director as a co-petitioner. It's a problem because 19 is for citizens, right? If the citizen is not before the court, I can't argue 19. Nobody can argue 19. That's the problem. So therefore, I'm always advising, please, 14 is yes. We all say 19, but we can't argue 19 unless there is a petitioner in person there sitting as a petition number 2, where 19 can be invoked. So I won't say it is res judicata. 19 can still be agitated. And if agitated, we don't know how the courts will do. So it's time to get back to war. And I'm not here mongering for litigation. It is on a plate. It is staring at you with this amendment. And therefore, group up, think it through, strategize. I've given you seeds of thought. Take it through. Thank you very much.
Thank you, sir. Any questions?
Thank you, sir, for the enlightening presentation, especially on Safari. I have one question on the revision and reassessment proposal under Section 18A, which has been introduced now under the Customs Act to sort of overcome ITC. They start, if you read the provision 18A, it starts with a non-obstante clause. It says, notwithstanding anything contained in Section 149, there will be a revision and reassessment. So is it a case that as you said, that there are time limits also which have been prescribed to claim refund, etc. So is it a case that now 149 is rendered redundant insofar as classification disputes or wherever I want, if I have short paid, I want to excess pay and take credit, or if I have excess paid, I want to claim refund? Is it that I don't have any recourse to 149 anymore? And if the time limits prescribed under 18A are exhausted, or there are certain exclusions also that if there is an audit pending, etc., you cannot go under that. So what is the relevance of 149 and why is there a non-obstante in 18A?
See, 18A is, like I said, is a beneficial thing. Government is not forcing you to get into that. The government is saying that notwithstanding whatever happens in 149 or all the vagaries of that, you can still access this. But if you are not falling into 149 for whatever reason, they don't stop, you're not falling under 18A, they don't stop you from going to 149 because all 149 is still in the statute. So the old law for 149 will continue to apply. The difference is that you will have to go through the process of satisfying his discretion and ego. That's the only thing.
So my name is Sahana. I just wanted to ask you 2 questions on the Safari discussion we just had. So you seem to suggest that, the conditions of own account and of plant and machinery are independent conditions.
That's
They're
right.
not cumulative.
They're not.
But I just want to take your thoughts on why do you think the Honorable Supreme Court remanded the matter back in the context of malls, specifically to the Orissa High Court to determine whether that qualifies as a plant, despite saying that leasing qualifies
Yes,
as.
the
an
reason for
outlet?
that is simple. You see, what the Supreme Court did was, it was deciding the issue in rem. if it were to make a declaration for one party, then there would be confusion for the others. Mall may be an easy thing to identify, but warehouses, cold storages. It is only for that determination the Supreme Court's, having written all of that, said that, well, I've drawn out the principle, now you follow it. You do the investigation, fact finding, and figure it out whether it meets the thing or not. And in that context, it was fair. It's not a re-adjudication of law, it was a re-adjudication of facts. Connected, it's a mixed question of law and fact in that sense. You look at functionality test, if it meets all of that, then it's plant and machinery or plant or machinery, then everything follows.
The remand doesn't infer that, these tests are cumulative.
No, absolutely not. In fact, it was never cumulative. And that's the first thing I said. There was another school of thought floating around that it is cumulative. I don't buy that because Supreme Court says, even if you read it, it says, other than plant and machinery, then on account. So if you fall out of plant and machinery, then that line stays, no? It's an independent thing. So a bracket within an exception is a separate exception. That's how it should be read.
Thank you, sir.
Any other questions from the audience?
That is one gentleman.
Hi, sir, I'm Vishnu. Thank you for the scintillating speech. Just right? And retrospective and retroactive taxation came to the government to sort of be immoral. So when you talk about morality, you perhaps come from a point of legitimate expectation of the taxpayer. The taxpayer feels through the law says, I've avoided by the law, therefore I not suffer any disadvantage. But when the government comes to court and says, this is how I'm interpreting the law, or rather I created the provision, this is how I see it, then can we really claim legitimate expectation? When I don't get the court say that this is what the law is, the government comes to court and this is what my provision says. Can we really argue from a point of expectation?
No. So legitimate expectancy is not what I'm canvassing here. Legitimate expectancy is very, very inferior right. Very, very inferior right. It always, seldom does it resurrect. Mostly it gets trampled. So we're not talking about legitimate expectation. I'm talking at a 80,000 feet, much higher level. At a jurisprudential level. Nobody doubts the parliament's supremacy in making retrospective legislation. Nobody doubts that. But at the same time, there is something called certainty of law, a very fundamental canon of taxation. People expect certainty to carry their affairs. Why do they say that substantive changes will be prospective and procedural changes will be retrospective? Why do they say that? That's the lex prospective, non res respice. That's the maxim. To say that, look, people who have suffered a law, their clock should not be set back. That's the morality. That's the morality. That's the purpose. That's why law is all prospective and never retrospective. That's the morality angle of that. Yes, you may have the power. But should you do it every time that you lose before the Supreme Court? And come out with a savings clause, taking it back in time. Vodafone happened, right? ITC. You take several judgments overturned because parliamentary supremacy. Now the time has come to ask these questions. That yes, you may be supreme, but when you make retrospective legislation, the judicial review power of the constitutional courts can step in when these yardsticks are not satisfied. Is it curative? Is it confiscatory? Is it touching upon vested rights? What is the length of time? And trust me, not only rich jurisprudence in India and the American jurisprudence also, there are galore judgments. At the right time, I'll show all of that or talk to you guys about that. Now it's too premature. And this principle is not an overnight principle from a textbook. It has evolved over hundreds of years of jurisprudence. So there is that morality of taxation that yes, you may have that power of retrospectivity, but sir, this is not the place where you should have used it. This is not the case because it is unreasonable to the boot. That's the point. Thank you.
Point would have been raised, I suppose, in that review petition. So probably that is still open for till the.
No, I was speaking to Venkat yesterday. We were having a chat. He said that they are withdrawing their review petition. So I don't know. I have not got an official thing. Says
Maybe
that-
because of the retrospective amendment.
Maybe. I don't know. I really don't know. But I don't think it makes sense for a review petition now with that amendment has happened.
The point on own account, assuming they withdraw the review petition, then the own account point then still stands final in a sense.
Of course, superior.
Just taking back you to customs amendment. As you said, for provisional assessment, they've now brought in a time limit under the act, which was hitherto not there. But it's a provisional assessment when it's given, the terms are also determined, whether you have to furnish a bond, bank guarantee, there may be a provisional duty payment, etc. They don't say as to what happens if the time limit is breached. See, in some cases, at the time of provisional assessment, the assessee may not be paying anything. So is it the case that the provisional assessments are deemed to be finalized? Or in some cases, the assessee may be paying a higher duty which he doesn't want to pay because the term set out in the provisional assessment. So what happens in a scenario where the 2 years plus 1 year extension time expires and I'm not falling under any of the exceptions, then what happens to those provisional assessments?
Those provisional assessments will be deemed to be final.
Sir, but that I can understand in a scenario wherein it's a simple case of bond, in a sense that the importer is at a beneficial position because of provisional assessment. But in some cases, the terms of provisional assessment are such that I am forced to pay higher duty under provisional assessment, under protest or whatever. Then in which case the importer will be in a worse off position because he is not getting a refund because he is under provisional assessment. And also that what happens, there is no provision which says that it becomes finalized.
But see, when there's a time limit, again, it's a principle of administrative law. When an authority is conferred a time limit, then he is bound to follow the time limit. Failure to do so is a non-discharge of statutory function, and therefore you can ask for various kind of relief from the court. It's a very fundamental administrative law. Okay.
Thank you. Thank you, sir. That was a very insightful session. Thanks to our distinguished speakers. I now invite Mr. A.S. Sriraman, Joint Secretary of the Revenue Bar Association, to render the vote of thanks.
On behalf of the Revenue Bar Association, I would like to express our gratitude to Mr. Lakshmi Kumaran Advocate for taking the time to be with us today and to share his views on the policy aspects of the union budget, drawn from his expertise as a fellow at Niti Aayog. We would also like to thank Mr. Raghavan Rambhadran, who is part of our association, for being with us here today. We'd like to express our gratitude for Mr. Sujit Ghosh, Senior Advocate from Delhi, for having made the trip all the way to Chennai to be with us today and to share his insights on the indirect tax proposals in the Union Budget 2025. Thank you, sir, for your time. To all the attendees who are present here, members of the RBA, advocates, chartered accountants, professionals from other fields, as well as students of law, we trust there is lots to ponder over from this budget, and the same would lead to further meaningful discussions and deliberations. We hope to see you at our next event. We thank everyone present here and request everyone to join us for lunch. Thank you.
Thank you, sir.
On February 20, Revenue Bar Association will be celebrating the 63rd Foundation Day. Stay tuned for further updates on this.
Thank you, sir. With that, we conclude the program. I request you all to raise for the national anthem.
विनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा हिमाचल यमुना गंगा जल जगति तरंगा तब शुभ नामे जागे तब शुभ आशीष मांगे गाहे तब जय गाथा जन गण मंगल जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Join us for lunch.